So if we reach this issue, it has tremendous implications outside of PROMESA, doesn't it?
Yes, Justice Sotomayor.
Now, let's go back to the foundational question by Justice Thomas and Justice Roberts. Territories like Louisiana and others didn't have their own sovereignty before they became territories of the United States, correct? They had sovereignty of France or of other countries, correct?
In most cases, yes.
And historically, no territory was dragged into federal or state or territorial courts unless their sovereignty had been waived, correct?
Yes.
So in 200 years of our history, the Justice Holmes proposition that no sovereign, which I think we have given to mean no governing entity, would be dragged into a court without the consent of the sovereign, correct?
Yes.
And so to the extent that the United States has not permitted, entertained, looked at suits against these territories, they've acted akin to states, correct?
Yes.
That's what we said in a long line of cases in Rosalie and Imadolin. We said that Puerto Rico is like a state, correct?
Correct.
All right. Having taken those propositions as a given, assuming we have sovereignty, the government, not the government, but your adversary says, okay, it acts like a state now through the 1952-54 Act, but that means it only has sovereignty in its territorial courts. It doesn't have sovereignty in federal court. Address that subset of the argument.
Justice Sotomayor, it's our position that this two-tiered theory of sovereign immunity, that Puerto Rico only has immunity in its own courts, that there's no precedent for that, and that in fact it's very counterintuitive, or would lead to very counterintuitive results. There's no authority of a situation we were able to find where a court has ever said that a sovereign only has, or this court has ever said that a sovereign only has immunity in its own courts. And it would lead to a lot.
And in fact, that's what Holmes was talking about, that the general proposition was broader, that you can't be held into a court.
Yes, exactly. And the second point is it would lead to some very strange results. One of the results would be that the territory, let's just say citizens of the territory who tried to sue the territory in its own courts would not be able to, because by hypothesis, it does have immunity in that situation. But then non-citizens, taking advantage of diversity jurisdiction, could sue under the exact same law in federal court against the sovereign. It really doesn't make sense.